Hi guys, it's Kathy. I hope you're doing well. I'm not muted. Let's just get this over with real quick. Oh, it's already muted. Oh, this is completely different than yesterday. There's a problem with my eye. Let's just move past it. I can move past it. You can move past it. Um, yeah, something on my screen. I don't like that. So I have three clips today. I got a guy who's just guilty, but it's not really his fault. Judge, judge. It's not my fault, judge. It's just not. Which usually works. Maybe, you know what? I wonder if more people would say to the judge, "Judge, calm down. Calm down, judge. Did you try smiling yet today?" Yeah, something like that. It's been a night. So, remember yesterday there was this guy that came into the bar who won trivia. He's really smart. He We were talking about Lord of the Flies, we were talking about Xerox, we were talking about a whole bunch of stuff. It was all great. Well, I'll be damned. He walked into the bar tonight, like 20 minutes after I started, and I thought, "Oh my gosh, he's back." Sat right with me. He started talking, and then he snatched victory right out of the jaws. I mean, he snatched defeat right out of the jaws of victory. The guy had so much to talk to me about. I work at a freaking bar. Everything he said to me tonight, I've heard a million times before, and yeah, idiot. So, you know what I did? He said he said he was coming in tomorrow to see me. He's changing his all of his plans for this business stuff that he's doing in town tomorrow so he can come in and see me tomorrow night. And I'm like, "Yes, that sounds great. I start at 5. Come on in." And then he walks out the door and I just turn to the left and the other server says, "Yeah, of course I'll take your shift." So I have all day off today and huge plans. I have huge plans. I'm not going to tell you what they are, but it's going to happen today. And you please don't feel like you have to participate. This is an optional only participation at any time you feel like it or don't feel like it. It's up to you. But after Judge Fleischer's stream today, I am going to tell you what it is because I can't. After Judge Fleischer's stream today, I am going to go into the members only area and live stream for a long time. I got some trials that are just piling up on top of each other, and I'm just going to stream today. I'm going to be streaming all day. That's why I'm saying don't feel like you have to participate. This one is hefty. Oof. And also, if you want to drop in at any time and leave at any time, that's fine. And I'm just going to keep going. I'm just getting all this stuff and I'm just doing trials today. I'm gonna pause whenever I want to, and I'm gonna talk whenever I want to, because it's gonna be in the members only area. So that's what we're doing today. And I'm not working today. I am gonna have her. I'm gonna call her. And I'm gonna have her call me when he comes in and put her phone down. Idiot. What an idiot. Okay. I'm going to start with this guy because it's gonna just build on this theme that I was just talking about.
Requested no contact order
Oh,
be put in
wrong
place. So this has
clip.
been uploaded.
Wrong clip.
There's allegations of drug use
This is a whole different guy. Don't worry.
as well. In the reports of the city would be requesting pretrial monitoring with UAs.
Lori, I hope you're feeling really good, love.
Also, the defendant has a few cases with warrants. Obviously, you're just about to deal with one that's been in warrants for numerous years, which was a physical control to reckless driving. That's from 2019. That post-conviction probation case has been in warrants for a very long time. Looks like he's got at least 5 or 6 other cases with warrants. Probably most significant, though, is Mr. Fox's domestic violence history. From my count, looking at his
Thank you, Casey.
felonies, it looks like he's got at least 2 prior assault DVs, 2 prior violation no contact order DVs, an interfering DV, as well as an unlawful imprisonment. So quite a bit of extensive domestic violence history combined with his lack of appearance for post-conviction probation out of this court. The city's recommendation today is $5,000 performance bail, as well as the pretrial monitoring with UAs due to the alleged drug use, in addition to the no contact order.
Okay. Thank you. Mr. Powers, would defense like to be heard on this?
Your Honor, I'm working with very limited information this morning. I think the defense will reserve
Today. Okay. So,
Hey, Your Honor.
yes, Mr. Fox.
Your Honor, if I just told you, just go ahead and plead me out right now, would you?
Can you repeat that? I didn't quite get it.
He said he wanted to plead.
If I tell you I'm guilty,
You want to plead out?
could you just plead me out? Yes, right now. I don't want to wait around for all this madness. And I don't have no 5 cases pending. I don't know what they're talking about there.
Oh, I just to be clear, in regard to the 5, it's previous convictions, I believe, is what the city attorney was
Guys, there's some bad words in this one.
referencing, as well as the warrants, previous cases with warrant history, just so we're clear.
Oh.
All right, well,
I don't
guess.
have anything. I haven't been in trouble, Your Honor. I've had an apartment. The VA got me an apartment. I've been working with my partner. I left my
All right.
apartment. I asked
So, Mr.
this
Fox,
young lady to leave.
Sit tight
She
for
would
just a
not
second,
leave.
Mr. Fox. I'm going to hear from the parties and see if there is. I mean, I guess essentially we've gone through arraignment, but I mean, is there any offer made today?
Well, I don't
we could-
have one. I mean, my best. We would need to set up our sentencing anyway, and with his history, he'd still be here Wednesday.
Yeah.
If that's what he wants to do, we can make him an offer that he could resolve on Wednesday. And if that's what he wants to do, we would need
Okay.
to have at least try to reach out to. I'm aware, and I'm not even sure. if they
Okay.
get conflict
Yeah, I'm tired.
for
I
this
just-
too, so.
Okay. So, Mr. Fox, here's where we're at procedurally. Technically, we have already gone through the arraignment. I've entered a not guilty plea for you, but what we can do is, just like the city attorney said, if you want to try and get this thing wrapped up quickly, you're right, you
Yeah.
certainly can. We can just set the case over to Wednesday morning, and I'll appoint you an attorney today. You can figure it out in the next couple of days. Does that work for you?
That works for me, sir.
Okay. All right. Well, here's what I'm going to do. Defense is reserving on release today. So if there is an argument to be made, that can be made in the future. But for today's purposes, I'll grant the city's request, $5,000 bail to be ordered. The court does make several findings based on the prior convictions, both for assaults and no contact order violations. There is a risk of a violent offense being committed. I think there's also a risk of the defendant interfering with administration of justice. So based
That's
on
why I
those
get
findings,
bad
the bail
stuff.
will be ordered.
Gotcha.
I'll find you eligible for the public defender then, Mr. Fox. I'll get you an attorney on board. I am going to order, technically, I understand you're probably going to be resolving this shortly, but I am going to order there be pretrial supervision. So if the bail is posted, you'll have to report to the Whatcom County District Court Probation Department for that supervision. I think that there is clearly a nexus between substance use and the allegations here. You also have prior history that would indicate substance use problems. So you would have to report. They are located on the 4th floor of the county courthouse. I understand you're on probation for another case, so I have to assume you know where they're located at, Mr. Fox?
I guess I don't know about my probation.
Okay, well, we're going to address that one next. They are, again, you'd have to walk over to the courthouse upon any release from custody, check in with probation for pretrial supervision. Other conditions, Mr. Fox, appear timely for any scheduled court hearings, have no new criminal law violations, do not have any drug or alcohol related infractions, do not use or possess alcohol, non-prescribed drugs, or marijuana, don't enter any establishment whose primary business is the selling or serving of alcoholic beverages.
Your Honor, I'm dying anyways. So
Okay.
what point is to that?
So, Mr. Fox,
I've got Parkinson's. I've got
Okay.
several other things going on with me. What's the point?
well,
IBS.
Mr. Fox, I understand, obviously, you don't agree with it.
She
and that's
came into
fine.
my home. She's
So,
not
Mr.
even
Fox,
on my lease,
Mr.
Your
Fox, I
Honor.
don't want you to talk about the facts of what happened here. You're going to get a chance to talk
But
with the
it was
lawyer.
my home, and she had me arrested in my home.
Okay,
It's not her
Mr.
home,
Fox,
it's
this
my
is
home.
not the day that we're having this sort of legal argument. You'll get an opportunity if you either want to go to trial or if you want to enter a guilty plea, you'll still have an opportunity to speak at that time.
Your
But
Honor,
we're not
y'all
talking
not
about
gonna
the
give me no
facts.
justice whatsoever. Y'all gonna give this woman that's out there on the streets all the justice that I deserve. It was my house.
Okay.
I asked her
Mr.
5
Fox,
times to leave.
I
She would not
understand that you
leave.
have a lot to say about this, Mr. Fox, but today is not the forum for it. You're going to have a
Yes,
chance to
sir.
talk to your attorney.
All right, Your Honor, I'm leaving, Your Honor.
We're
I'm
not
gonna have them take me
we're not
back
quite
to
done
where.
yet, Mr. Fox. If you want to leave, you can, but I'm not done with the order here, so give me just a minute. Last condition here, due to previous conviction, you're not to own or possess firearms as a condition of pretrial supervision.
I don't
here.
care about that
The
shit.
court is going to enter a no contact order as well. So
That's
here's
fine.
what I'm
Stay
going
the
to
fuck
do.
away from me.
We'll set the pretrial over then. Is everyone fine just doing Wednesday morning?
Sure.
All right, Wednesday, 9/18 at 8:30. I'll do an out of custody. Where are we going?
I can't believe y'all have me arrested and she's the one that's
All right,
doing all the shit.
11:14.
But wait, there's more.
Did y'all arrest her? Of course not. When she
Probably.
came and home invaded my place and y'all don't let her? I mean, I get arrested?
Mr. Fox, please remain silent.
Who's that said that?
That was Mr. Powers, and he is the public defender here in court. And I would suggest you listen to the attorney, Mr. Fox. You probably don't want to say any more.
Yeah, he's gonna bend me over a little bit more, right?
You
All right,
wish.
here's the no
Thank you.
contact order, protects the party by the name of Larissa Slesarchuk. It does prohibit you from doing a number of things.
I
here.
don't
So-
care. I don't care. I'm never gonna see her again,
All right,
hopefully.
well, I'm still going to read it into the record, sir. Do not cause, attempt, or threaten to cause bodily injury. This does include any type of assault, harass, stalk, or keep under surveillance the protected person. Have no contact with them whatsoever. Face to face or third party. It does include electronic.
Your Honor, I tried that.
Okay,
I
Mr.
tried
Fox, if
that.
you don't stop
I tried
interrupting me,
5
we're just going to
different
have you removed from the courtroom, sir. You got to let me finish talking. Do
Okay,
not know where
Your
the
Honor, I'm
enter,
sorry.
remain, or come within 1,000 feet of the protected person's residence, school, workplace, vehicle, or wherever they may be. This order also indicates you're not to own, possess, control a firearm, and it is a pretrial order, so it's going to remain in place until the case is resolved, unless it's modified or rescinded in the meantime. I am going to sign off on the no contact order. And then lastly,
Thanks.
we do have the probation case here. Mr. Powers, I'm starting to think this may not be something that can be resolved necessarily on Wednesday. Or you think that's going to give you
He's
enough
looking
time?
at a revoke on his probation too, so.
So we
Like
Am
I
I
said,
right?
there's more.
Okay, we'll come back to the pretrial date in just a minute. Let's turn to the probation matter. I'm going to go ahead and pull that order up. Looks like we have a notice of violation on the probation matter. All right, Ms. Souza, looks like we have a brand new one dated for today with 4 alleged violations.
That's correct, Your Honor.
Okay, Mr. Powers, are you able to admit or deny the alleged violations today on probation?
Your Honor, at this time, the defense is able to deny 1 through 4.
Okay, there's 4 alleged violations, Mr. Fox. We're going to enter denials on all 4 of them.
No, they're all true. I'm
What?
not gonna waste the court's time.
You gotta watch the lawyer throw his pen down. It's awesome.
I didn't show up for probation, so therefore I'm not gonna lie.
Does defense feel comfortable just entering the admission?
Yes, Your Honor.
Okay, it's up to you, Mr. Fox. It sounds like it's against the advice of counsel, but if you want to enter the admissions, that's your choice. So,
I'm guilty of not reporting. So what's that gonna give me, 20 years?
okay, well, let's. I'm going to hear from probation. I'll enter admissions to 1 through 3. As to number 4, I'm still going to enter it as to charge only. I'm not going to enter it as a complete admission to the new charge. But admissions to 1 through 4, then, Ms. Souza, what is probation requesting?
Your Honor, we're asking for revocation and a 30-day sanction.
30 days. Okay.
Yeah, revoke it,
30
30 days,
days.
that's great.
All right, Mr. Powers, does defense wish to be heard on that request?
Nothing further, Your Honor.
Okay. Well, Mr. Fox, it sounds like that part is essentially agreed. So I am going to go
Yep,
ahead then.
this was from the
and
early
I am
90s,
revoking
definitely.
probation. Obviously, this is about a 5-year-old probation case. And as you just said, nothing really got accomplished on it. So probation's revoked on this case, serve the 30 days.
And hear me out,
Once you serve
it
those 30
was
days,
September
you no longer have any
16th.
obligations on that old probation case.
Wonderful. Thank you, Your Honor. I'm sorry for being such a dickhead.
It's okay, sir. I understand it's obviously a frustrating situation for you. Just give me a minute to finish up the order here.
Yes, sir, Your Honor. Thank you.
Okay, so I'm signing off on the probation order. So again, serve the 30 days, PR on that matter. Once those 30 days are done, you have no further obligations on that case. What I am going to do, however, because there's a lot of moving parts here on the pretrial and you have the 30 days to serve, I'm going to give your new attorney a little bit of extra time to get things in order on the pretrial case. So I'm just going to do the normal 2 weeks. We'll set it over to the 30th. And then at that point, if you're ready to resolve your case, Mr. Fox, that's completely fine. But I don't want to make your attorney try and get this all scrambled and figured out in 2 days.
Okay, that's fine.
30 days to serve regardless. So
that's fine, Your Honor.
Okay, so Monday, September 30th will be the pretrial date then on the new pretrial case. Okay.
It's
Mr.
normal,
Fox,
but it's still a bad word.
Thank you for being patient, sir. I've covered it all on my end. Do you have any other questions?
No, sir. Thank you for being patient with me. I know I'm be pretty out of there right now, but I mean,
that's okay.
The crap I've been through.
All right. Well, Mr. Fox, thank you, sir. I'll see you on the 30th.
Yes, Your Honor. You have a good day.
Thank you. You too.
Look how nice he got at the end, guys. It was all her fault. All her fault. Security, in the middle of that, I thought you said you're coming to the States soon. Not a new state in Australia. I got so excited for a minute, and then I was just crushed. This is a common theme for me. Okay, Lori, if you can hear, you just go to my channels and go to video. And these are regular videos. This was supposed to be a short. I messed up. These are all regular videos that anybody can watch. This one, boom, members only. There's Donald, members only. Members only. Uh-oh. And like some of them, like if they're really, really bad, then they're members only, but they might be like extreme members, not just like the $1 members, because I will offend them easily. Okay. Now we're gonna go to O'Donnell for a strange case. My sister? No, yeah, maybe I don't speak to her. I don't speak to my sister. You're right, Raven. Okay, let's go to O'Donnell. We haven't been to O'Donnell in a while. My goodness. Not him. Not him.
Just want to make sure this is out.
There. It's coming. He keeps it black and then he just
Having
turns it
pleaded
on.
guilty by information to 1 count felony of the 5th degree breaking and entering. Parties are ready to go forward.
Thank you, Mr. Watson.
Thank you, Your Honor. May it please the court. My client is a young woman. She's a mother. She just started LPN school, and she has a very bright future, I think, ahead of her, who unfortunately made a very poor choice that day. Her ex-friend, and I use the term ex because the co-defendant in this case that was handled through another court, she no longer has any contact with her. After this, she's completely cut ties with this woman. But her ex-friend had asked her for a ride to the VA. My client took her. They waited there 2 hours, and I know we had discussions in the court. Your Honor, my client simply didn't understand the law, And I know ignorance is no excuse.
Well, the problem here is not a misunderstanding of the law, but the problem is, from your client's perspective, what she thought she was doing there in those 2 hours.
I agree with the court, and I was just going to address that. She went there with her friend, and she should have, after a certain amount of time, said, "Why are we here? What is going on? You asked me to drive you here." I agree with the court. Now, I don't have a specific explanation as to why, but my client didn't. And during that time frame, the co-defendant had slashed this woman's tires, and then as soon as the victim came out, attacked the woman.
Sure it
Now,
is.
from my client's perspective, she didn't throw a punch, so that was part of the reason why she didn't think she did anything wrong. However, Your Honor, she and I know this is a dispute, but when the attack started, my client did open the door and told her ex-friend to stop and let's get out of here, let's leave. At that point, the attack was over. The co-defendant did get in the car, they drove off, and then my client contacted the police after the fact. She had heard, she thought that they would be looking for her, and I believe she voluntarily turned herself in. Your Honor, clearly, she shouldn't have driven and waited there for 2 hours. Clearly, she should have started turning to her friend saying, "Look, why are we here? What is going on? This doesn't seem right to me." And she didn't do that, Your Honor. She did take responsibility. She was, prior to this court, by way of information, she did take responsibility for her actions. Again, I mean, since then, she has just, I think just a few weeks ago, just started LPN school. She's trying to get things together, Your Honor, so she has a future for herself and her children. She is remorseful. She doesn't know the victim in this matter, Your Honor. She doesn't have a beef with her one way or the other. She had no idea who the victim was.
Maybe try logging in from the website, from the browser, instead of in the app.
She is sorry that the victim got attacked the way she did. She realizes her role in that, in the sense that she took her friend there, her ex-friend, to commit that crime. And yes, it took a little while for it to sink in, Your Honor, but she realizes
You
that
too, Mel.
yes, she did participate. Yes, she should have. There's a lot of things she could have done in that 2-hour window that may have prevented this, that she didn't do. And that's why she's taking responsibility, Your Honor. And I'm respectfully asking the court, based on the fact that she has no prior felony history. I know in Chambers, some misdemeanors came up in her past, but she has no prior felony convictions, Your Honor. She is in school. She is a mother to young children, and she has taken responsibility for her actions in this case. I'm going to respectfully ask the court to consider community control sanctions. Thank you, Your Honor.
Thank you. What do you want to tell me before I impose sentence?
First, I want to apologize to the victim. I want to apologize for the role that I played in it. I shouldn't have never took her out there to commit any crime. I wasn't aware that she was going over to fight anyone. I wasn't trying to fight nobody. I don't fight anyone. But I did cut ties with her, and a friend would never put me, I shouldn't be ever put in a position where I had to fight for my life, because this is my record. What I did just don't affect me. It affect my kids, my family, and my career. Like, me catching a felony is play a really big role in my life, like with school, with pursuing nursing, with my job. I do phlebotomy at UH. It did pop up, so I do have to tell them what's going on, and I might lose my job.
How did you know this Booker?
She lived in my building.
So why did she ask you to drive her somewhere?
I was off work that day. She called me like, "Can you give me a ride somewhere?" And I'm like, "Where?" I didn't really have any gas money, so she's like, "I'll put some gas in your car and I'll buy you something to eat." So we went out there, And I'm like, where are we going? So when we got in the car, she's like, I want to go talk to someone at the VA hospital. First, we went there. She did slash the girl tires. We left, went and got smoothies, and we came back. And the girl was coming outside, and she jumped on the girl.
Okay, but so after she slashed the tire,
Mhm.
why didn't you just tell her to get the hell out of your car and leave? If that's what she did.
Right. So when me not trying to be a friend and me not really thinking of it, not thinking that she's going to jump on someone.
I know, but isn't slashing the tire bad enough in and of
Yeah.
itself?
Yeah, it is. And then she was telling me, like, I'm like, why are you, I asked her, like, why are you doing this? And I guess prior to that day, her and the girl got into a fight. The boy, because it's over a boy, they got into a fight that night. And she was like, oh, I want to talk to her. I want to explain myself to her.
Yeah, but she slashed her tire. She didn't want to talk to her.
I'm not thinking she's going to fight this girl. Not.
Well, but I mean, if she slashed her tire, then you guys leave and then come back. What did you think she was going to do when she came upon her?
And she told me she wanted to have a conversation with her because, like I said, it's over a boy. She I want to talk to her.
Why would you believe that after she slashed the tire?
I've never seen her fight anybody.
But have you ever seen anybody slash a tire before?
No, I never slashed a tire.
I know, but that's a pretty violent act, right?
Yeah, it is.
So it's incomprehensible that you would think that she just wants to talk to her, because she was pretty pissed off in order to slash a tire, right?
Right. It's me not thinking the severity of it. Like, I'm just always saying yes or being nice. Like, I'm not thinking she's about to attack this girl. I'm not thinking she's that mad so she's going to attack someone. Like, I ain't never been in a position where nobody just attacking nobody, because I've been a victim before and I've been through it. And somebody came in, jumped on me before.
Your case is a very odd case, because I don't know what to believe from you or what to disbelieve from you. Now, didn't you tell the probation officer you had no record?
Right.
Why did you tell her that?
No, I told her back when I was 19, I told her that I caught a theft case.
What did she tell you?
There was no juvenile record.
When I was 19, I told her.
Okay, why did you tell her you had no juvenile record?
Petty theft.
Huh?
Petty theft.
Okay, but that's a record, isn't it?
That's
You
where
got 3 theft charges as a juvenile. You're in school for what now?
I'm in LP in school. I go to.
When did you start that?
I started it, I think it was the 15th. I have my offer letter. I mean, my letter. I think it was the 15th.
Where is it?
Right here in Willoughby.
How long of a program is that?
It's a 9-month program. I'll be done in May.
And then you're going to be an LPN?
Yes.
You're not going to have very much success if you're hanging around people like this.
I know.
When's the last, do you still live in the same building as this Booker?
Yes.
Have you seen her since then?
No.
You haven't seen her in the hallway or in the parking lot or anything?
I seen her probably like 2 months ago. I seen her. We crossed paths. We don't speak. We don't talk. Nothing. Like, we had like a little conversation, and I just felt like she put me in a predicament, like this predicament.
Well, it's not all, I mean, you may believe she put you in a predicament, but you put yourself in a predicament at the very least when this tire was slashed, and then you left and went back to the same place. So you're certainly not blameless in this whole matter, are you?
No.
I mean, it's clear that you didn't get out and inflict a beating on this person.
Mm-hmm.
But had you done what you should have at the very least done, not go back to that place after she slashed a tire, then the beating wouldn't have taken place, right? At least on that day, it wouldn't have taken place.
Right.
My guess is Booker would have tracked her down somewhere else, but it wouldn't have happened that day and you wouldn't be sitting here right now.
Right.
So you put yourself in that position.
Right.
So how old are your kids?
My son, he'll be 10 in October, and my daughter is 6.
And when this happened, where were they?
They were at school.
All right, anything else you want to tell me?
No, that's all.
Mr. DePiero.
Your Honor, the state would join in the recommendation for community control sanctions.
What state
The
is
state
that?
has had numerous conversations with the victim, in this case, Gloria Noble. She's not here today, Your Honor. We've had regular contact with her. However, she did submit a victim impact statement. Would ask the court to consider everything that she relayed in the victim impact statement. Also, I know that Ms. Noble would want me to relay that she feels very strongly about incarceration as a community control sanction provision. The state would defer to the court's discretion as to all of the terms of community control sanctions. There is no restitution in this matter.
Thank you. All right, I've reviewed the pre-sentence report and the victim impact statement. And listened to the defendant, listened to counsel. I considered all the provisions in 29, 29, 11, 12, and 13. I'm going to place you on community control for 3 years. Now, what's going on with that case that's in Cuyahoga County?
I'm still going through it with
When's the next hearing scheduled for?
the 26th.
Of this month?
Yes.
What type of hearing is it?
It's arraignment, I think, or pretrial, I think. I don't know.
Pre-trial?
I think so.
All right, I'm going to place you on community control for 3 years. You're going to serve 2 days in jail with credit for 2. You're to have no drugs or alcohol in.
That's Judge Slay's link. I don't know how often I don't know how often videos are posted on that link, but that's the link that she has. Actually, there's more than one. No. What is this one? Hold on, I'm going to give you another link. Oh, no, yes, I am. I don't know if there's a live stream on this other link. Courtroom streaming. Hold on, I'm going to give you another different link. Try. This one should be Washtenaw County. It's not on YouTube, though, so go at your own risk. Try that. And you might just have to, on that one, see when they're streaming. It says Monday through Thursday at 1:30 via YouTube. Please click below. Maybe they're different. Ouch. That's trial court. So, will you stop it? Yeah. Yeah. I wish it was easier. I wish I could just give you a link. But you gotta keep clicking. Keep on clicking. You'll find it. But there's links anyway. There's links. You can try. Will you stop it? Okay.
You'll be screened. You're to obtain and maintain. Are you still working at UH?
No, I do traveling STNA.
What?
I'm a traveling STNA.
All right. And then, so you're to maintain full-time employment or full-time school or a combination of each that equates to full-time? You'd have no contact with Samora Booker or Gloria Noble. You're going to pay the costs and supervision fees with this case. Ms. Cook, anything else?
No, Your Honor.
Now, I'm not putting you in jail.
I guess you're right. No one outside of Pennsylvania would know. Keep on scratching. Sorry, guys.
at this point because of your school and employment. Okay?
They might. Just wait until they're
That's-
live and look.
and
They
that's
might.
the only reason. But you're not, as I said before, blameless in what happened here. You're not blameless in this beating that took place. So you're getting one opportunity. Now, these terms of probation are pretty easy. All you have to do is live your life like you're supposed to live instead of hanging around dipshits like Booker, okay? And putting yourself
Vicky, this is a directory. Washtenaw County, I know I said that wrong, but you understand, go down to the W's, is where she is. And if you go to her YouTube page, she lists more links on her YouTube page. And on there, they go to separate links. So you can start here. That's all of Michigan. And then you can just click away until you find what you want to find in Michigan.
in positions, in a position that got you here. Okay, don't leave here blaming Booker for your lot in life as you sit here right now with this felony conviction, because it ain't Booker's fault. It's your fault. Okay, so you either get it together, or if you come back for violating these simple terms,
Or the other way around, I don't know.
then I'll figure out I did the wrong thing, and then I'll just send you to prison for 12 months. Do you understand that?
Yes.
Mr. DePiero, is there anything else?
Your Honor, should the court ever impose a term of imprisonment in this matter, could it be that is the court ordering that it may be consecutive to any other prison term that would be served at the time? Or
For
no?
what?
Well, we got another felony pending. I don't know. It's typically in the judgment entries. Now, the court.
Well, that's
speaks to whether
awkward.
or not
I don't know what to do.
a potential prison sentence in this matter may be run consecutive to another potential one in the future. I just want to make sure.
Well, if I don't tell her that, am I prohibited from doing that?
There is, I believe, an interpretation of the law that says that you are.
That's dumb. Isn't that dumb?
Well, as to whether it makes sense,
In case law or statute?
I believe it's case.
Did you hear what he just said? I know. I wasn't paying attention and stuff's happening in chat. But he separated it. He differentiated it. The lawyer's saying there's law that says you can do that. I don't know what he's trying to do. I have no idea. And also my gift membership is also broken. It's just spinning. So, but this lawyer says there's law that says you could do that. The judge said that's stupid. He said, is it case law or is it statutory law? So is one bigger than the other? Does one have more power than the other? What if they collide? I mean, that was interesting. I never heard a judge differentiate like that.
Okay. Well, I understand why you're bringing this up. But then I'm imagining that she's going to get convicted of something else. And that if I didn't tell her if she gets convicted of something else while she's on probation and I send her to prison, then it has to be consecutive.
Well, not necessarily that it has to be, just that it may be. And certainly the defendant would be presumed innocent of any charge that she faces in the future. But it's not impossible that anybody would be convicted of a felony while they're on probation.
Crazy.
Yes, Judge.
So,
But-
so I will respectfully decline to have that put in the judgment entry.
Yes, Your Honor. Thank you.
Because I think that's the craziest thing. That's the craziest interpretation that some other people have come up with. Anything else besides that?
No, Your Honor, thank you very much.
Watts, anything else?
No, Your Honor.
Okay, just do what you're supposed to do. That's all.
Judge is talking to
And then
all
you're gonna
y'all.
get the other,
All y'all. Except for you, Nan.
Entry, Mr. DePiero.
Yes, I will, Your Honor.
All right.
For purposes of the record, I'll just say the state will be presenting a written nollie to the court on the other case pursuant to the agreement.
Okay. Thank you.
So in case you missed that whole trial hearing, like I did, this girl had a friend who came up to her and said, "Hey, I need a ride. Let's go drive far away." And then they get there. I think it's at a hospital. I don't remember because it was only like 3 minutes ago, so I don't remember. Her friend jumps out of the car and slashes tires on her vehicle and then jumps back in the car. And then they sit there for 2 hours and wait. They leave at one point. What did they say, to go to McDonald's? They leave at one point to go to McDonald's or something, and then came back. And apparently that whole time they're just sitting in this parking lot waiting, eating French fries. She never turns to her friend once and says, "Hey, by the way, why are we here?" And after she jumped out and slashed the tires, she stayed there. So then finally, this person comes out of the hospital and her friend gets out of the car and beats her. And she gets out of the car and says, "Hey, can you stop beating her now? Let's go." And then they leave. And now she has a felony on her record. She has a felony on her record. First off, because she lied. Nobody drives someone for 2 hours and doesn't say, "Why? Why are we sitting here?" No one. Absolutely no one. I don't care how kind you are. But I don't know, if I drove my friend to the hospital because she asked me to, and then she got out of the car and beat someone up, I shouldn't be in trouble for that. I just shouldn't. Is it because she waited 2 hours and then in that time saw the tires get slashed that now it's a felony? I don't know. She didn't slash the tires. She just drove the car. I don't know. Okay, I just have a warning for everybody in chat. We are giving so much love to Lori because we love Lori. We always loved Lori. Please do not give yourself a heart attack so that you can get as much love as Lori does. You ain't Lori. You just ain't. So don't. Don't give yourself a heart attack. There was someone famous that had a heart attack the same day you did, Lori. I can't remember who it is now, but they didn't fare so well. I think they were from like a 70s band or a 70s TV show. I don't know. Yeah, Lori is awesome. No one's Lori here. No one's Lori but Lori. Monica's very, very close though. They're like twins, right? Maybe they're the same person. Maybe they're both men. Anyway, let me see. Okay, I think that some of you should leave now. Um, it's time for some of you to go. I'm about to go on to the next trial, and it's about a DUI, and it's about an unlived person during the DUI. Someone gets unlived during this DUI. So if like these are court cases, and criminals do crimes. So if this is highly offensive to you or triggering, or you had someone in your life who was unalived by a DUI person, then maybe this next clip isn't for you. And maybe, you know what? Oh, I got to show you something. I have something for you to do that you'll love much better than unalived DUIs. Oh, just let me find it. I have two websites. Um, the first one starts with a W, but my things aren't in alphabetical order. Hold on, just give me 2 seconds because you're really gonna like these two websites. I'm looking. I have a lot of websites saved on YouTube, guys. One of them is how to crochet tiny little, what are they called? when you crochet the tiny little animals, what are they called? There's a word that's escaping me right now. And the I don't see them. Of course, I don't see them. I need them. Something I need during the middle of a live stream, and I can't find it. The other one is just the cutest little Japanese baker who makes the cutest little cakes in the entire world. Pima County. I have a lot of courts in here, guys. That's a good one, but it's not great. Java, you want to learn how to code in Java? That's a good one. Nope. Nope. My computer hates me. YouTube has always hated me. Nope. So just Google it yourself. Tiny little crochet. What are they called? Caraba? Not the Australians. Don't tell me I need an American. Caraba? Do we call them caraba? Caribou? Go crochet some caribou. The little yes, that's it. Do that instead of watching this. Or watch it and then give me all these comments about how horrible it is. That's up to you. That's all you. We're going to go into a DUI case because we see bits and pieces, all right? No, Fozzie. We see bits and No, no, that's not the right word. It's a little rat or a big rat. I'm sorry, it's a big rat. I don't think it has a tail though. It has like a bob for a tail. What is it called? No, 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 it's a big rat. Come on, you know what I'm talking about. Yeah, YouTube isn't going to be able to help. I mean, Google isn't going to be able to help me because Kappabaru. I think that's it, but that's not how you spell it. Guys, help! We're almost there. Capybara, capybara. That's it. That's what I'm talking about, but that's not how you spell it. Peg leg for the win. Boom! Smoked everybody except for Sarah. Sarah was right there at the same time. I just think that y'all need to go. Oh no, one of you are wrong. There's either a Y in it or there isn't. It looks like there's a Y in it. Peg leg for the win. Go crochet those. Go crochet those. Now you know what it's like living to me. I say this word to my kids, like part of, or like, that song with that guy in it that goes out in the rain. What's that song again? What's that song? And I make them find that song for me. It could mean anything. And it's usually not like even rain, it's sunshine or whatever. All right, it's time. I gave you all your warnings. This is a DUI case. Someone is unalive. There's pictures, there's video, the body cam, there's pictures of the crash, there's pictures of the car, and there's pictures, we're watching him do the field sobriety tests and everything. It's really the end that gets the lawyers fight so hard. Both lawyers. The defense attorney, no one's gonna like because this guy's a scumbag, but he is outstanding. Yes, that's what it is, the Pina Colada song. How did you know? Now you're my child. Afternoon delight. That one too. Showtime. There it is. Oh, I guess I cut this was like a 2-day trial and like 16 hours of trial. So I cut it all out and just gave you tiny bits and pieces. We're looking up here. It goes quick.
Do you recall seeing a semi truck in front of you or in front of the cars that particular morning? I do not.
Up here is where the crash is. He's going like 125. She pulls in front of him, going a normal rate of speed. Is that it right there? Yeah, that's it right there. There, he hit her. And now the car's upside down and they're off the road.
See this car moving? Is that you?
That would be,
And that's you coming to rest at the,
Additional units, medical units, and care flight to be put on standby.
Yes.
were you equipped with a body camera that was recording your
I
actions
was,
that particular day? And it was on?
Yes, sir, it was.
Did you turn it on as you were making your way to the crash scene?
So our body cameras activate automatically upon our door being opened. When our door is opened, the body camera activates and you will hear sound. It also backs up 90 seconds. So the portion of my video that is captured by my body cam where there is no sound is the backup portion where it sort of retroactively records. And then where the sound begins is where it's activated by my door opening.
So I have.
We all
Washington
do,
State's
all of
exhibit
us.
Number 6 that I would ask to play for the purposes of you at least beginning to identify this particular exhibit. Does that look familiar to you, Sergeant?
Yes, sir. That's the inside of my patrol car as recorded on my body cam.
And this would be the start of your body camera on that day of April 2nd.
That's beef
2023.
jerky.
Yes, sir.
It
There's
says
a time
snap
stamp
into
up
a
on
Slim
the top
Jim.
Right, it says
Slim Jim.
11:04:09. Does that appear to be?
Sorry, this is more important. Do they have Slim Jims in Australia? You guys get to have Slim Jims? Is anybody here from the UK? Do you guys have Slim Jims? I have to know.
At least approximately the time right before, well, I guess you said would be 90 seconds before you arrived and opened the door of your car, right?
Yes.
This time I'd like to go ahead and play that.
Before we do that, Mr. Hardman, to Ms. Jump and folks in the Coletta family,
And how many of you Americans are saying snap into a Slim Jim?
I don't have a rule about coming in and out of my courtroom. So if you want to leave during this portion of it, if it's something that you don't want to watch, I haven't seen it, so I don't know what we're about to see. So if you want to step out, that's fine. If you want to step out now, that is also fine. If you decide at any point you would like to step out, that's fine too. You can watch it on YouTube from the hallway if you feel
It's
better
a
about
meat
that,
stick.
or from one of the private rooms that's out there. I don't know what we're going to see, Mr. Hardman, but
I will say, and we've kind of warned the family about that this is the next portion of this would be if they feel like they do not wish to see portions of their loved ones' interactions at the car, this would be the time for them to
generally these body cam footages are a little much.
I'm going to go ahead.
If you change your mind, just step out. Go ahead, Mr. Hardman.
I'm going to go ahead and just move this up to the 1:30 mark.
It's absolutely processed over and over and over.
Yes, sir. This is you approaching the scene of the crime. Is that a scene of the crash? Is that correct? Or where the cars came to rest?
Yes, sir, it is.
Right there on the left side as you're approaching. Sorry.
Irish Dublin, hello.
Yeah, I'm gonna say he's crashed.
Pause there at the 1:52 mark. That gentleman to the left there Did you come to know who that person was and how he was related to this particular scene?
Yes, sir. At the point in the video that we're at, I did not know that he was the driver of the Genesis, but I would later, through the investigation, come to find that he was the driver of the vehicle located to the right of our screen, or on the right portion of the screen.
And you come to identify him as Samuel Sperry, is that correct?
Yes, sir.
And do you see him in the courtroom here today?
He's seated at the defense table.
There's two people there. Can you tell us which one?
I'm sorry. He's on my left. It would be the right as he faces the court.
Record reflects identification of the defendant, Your Honor. Noted.
Hi, sorry. I didn't see the accident happen. First responder, driver's not conscious, but the passenger is.
Driver supervisor telling me he has to step it up. Driver is unconscious, serious head injury. So I just pulled up. How you doing, Trooper? Just pulled up on this accident. Who was in this car?
You're so bougie.
Were you in this car? Okay. Is there anybody else?
No, there's no one else in the car.
As far as you could. Yep.
I'm right off the
John Edward X-ray 2246. John Edward X-ray 2246. Driver is minor injuries.
Can you place air care on standby?
What? Air care on standby.
Yeah, air care on standby.
There's an off-duty medic on scene requesting air care. Get on standby. Let county know. Fire EMS is rolling up now. Break connected.
I'm gonna clear out. That's her purse. I didn't see it happen. Sorry.
They taste good with beer.
6729. Driver still unconscious. He's going to be in crash.
Conscious, no neck pain, answering questions. Yep.
And his car is hurt, but not that hurt.
I'm about to do a statement. I got a supervisor coming. They want air care on standby. I heard that. I'm gonna have to. We'll get a statement from these guys for you. Thank you. Make sure. Can you get his phone number and date of birth on the statement somewhere, please? Thank you. You need to get checked out. Okay, you got a laceration. Get checked out. I'm gonna need
No, Raven. It's in Ohio.
If things go south, we're gonna have to shut the roadway down. Okay. Yeah. Yeah, it looks like it started way back there. Yeah, it looks like it started in the left lane, so yeah, I saw that. We're gonna shut the whole thing down if we need to. As far as I know, it's just these two cars that were actually involved. Everybody else. Yeah, it sounds like it's okay. So I'm gonna start taking pictures. Want me to take him back to one of the medics? Yeah, go get checked out. I don't know if they got another medic around. Let the medics check you out. I'll get with you to get your statement. Okay.
That guy in the blue was the driver going 125, 135.
It's like 3216.
Yeah, so at the 20/4, you can see where they come off road.
Three different ways he's not sober right now.
Yes.
Three.
I believe this is where I take his statement.
Sorry about that. Had a lot of stuff I had to take care of. Let's do this first. Is there any way we can put some lights on? Thank you guys. No problem. All right, so I need a statement
That's
from
not
you about
me,
the
that's
crash.
them.
Okay. So I'm going to.
I'm a
give you this to
professional.
fill out.
So, what's your phone number, sir? Now, what I need you to do is print your name at the top, put your current address and sign it, and then answer the question what happened. When you're done with that, I'm going to ask you some additional questions. Okay?
He's about to write down what happened, and we're going to read that later. Okay, Boomer.
Information only, northbound home review remains shut down for a certain amount of time for the investigation. Also, Deerfield unit will be on the campus.
I'm Gen X.
Clearly northbound lanes and Deerfield units. 1140.
Fozzie, I think you are Gen X.
I wasn't. All right. Samuel, were you injured?
Just the face.
Just a cut on your face? Or is it, what is it? Is it just a cut?
Yeah, just, taking the airbag to the face.
Okay, Boomer.
You're wearing your seatbelt?
Yes.
Okay, Boomer.
Do you know about how fast you were going?
I would guess like 75.
Were you distracted by
No,
anything?
you're a Boomer.
Have you drank any alcohol, smoked marijuana, used any prescription medications, or taken any illicit drugs today? You don't take any prescriptions?
I take prescriptions, but not today.
Not today. Okay. What prescriptions do you take?
Klonopin.
When's the last time you took your Klonopin?
Probably last night before I went to bed.
Okay. Anything else? So high blood pressure, diabetes, anything like that?
I do have high blood pressure.
Do you take any medicine for that?
Yeah, I do. It's called Sartan.
Okay.
Yeah.
No illicit drugs, no marijuana, nothing like that. No alcohol.
I don't know what it is.
Do you need in here? No, you're good.
Let's see the ones I've made for Fozzie. Let's see. I know there's two. Hold on.
Where were you coming from? Where were you trying to get to?
So I was coming from my house in Hyde Park. I was heading to the golf course in Mason, New Grizzly.
You said Hyde Park?
See, Fozzie, I don't bully you. I only have 2 insult banners for you.
Yeah.
And you were going, sorry, I gotta write this down. So it's,
No, you're good. I was headed to the Mason golf course. It's called the Grizzly.
okay. So you were going northbound?
Yes.
The other car was going northbound?
Yes.
You say you were in the left lane and you were trying to go to the right lane, and then you don't remember what happened after that?
I just, hit a bang and, kind of came to over there.
Liar.
How many use the question?
I'm alright. My main concern is how I live.
I understand. So.
Speaking of prawn, hi, legal fiction.
Just a little lightheadedness.
Is there anything you'd like to
Yeah,
add to
well,
the statement?
that doesn't help. I don't know what that is either.
After I asked you questions or anything that you want to put back, or anything else you want to say after all those questions?
No.
Okay. All right. Is he cleared automatically?
Or you guys-
Yes, yeah, I've tried his vitals, checked his bugles, looked for seatbelt signs, no other complaints than just fine.
So you guys are done with it?
Yes.
So Samuel, I'm gonna ask you to step out here to my car. I'm gonna ask you to do a couple of standardized field sobriety tests just to make sure you're not impaired.
Why, do you have some?
Roll that out.
What?
With, what happened, okay?
What, half
before
of
we do
what?
that, I'm gonna tell you a couple things. You're not under arrest.
Asking
okay?
for a
I'm gonna
friend.
ask you, potentially incriminating questions, okay? So you do have the right to remain silent. You do have the right to an attorney. If you cannot afford one, the court will appoint one to you. You have the right to speak to an attorney prior to answering my questions. If you choose to answer questions now, you can stop answering questions at any time and ask.
Does Wikipedia tell you what happens if you're on cocaine, marijuana, and alcohol while taking that, whatever that is?
To speak to an attorney. If you choose to answer questions now, you can also stop answering questions anytime for any reason. So basically, I'm going to ask you some questions, and you don't have to answer them if you don't want to. Does that make sense? Understood. All right. So I'm going to have you come out here, back to my car. I'm going to do a couple quick field sobriety tests, make sure you're all right, and then we'll make sure that they don't need anything from you, and then we'll go about.
My drinks are so hidden at work, even I can't find them half the time.
Getting out here, right?
Pause right there and show you what has been marked as the response to his questions.
I did.
Hold on.
That circle
This is
part,
his
that
response.
No prompts other than what happened. His
Yes, he was provided with the question, what happened, and the Q and the A, and then he wrote what is circled.
Go ahead and read that.
I was in the left lane, went to merge into the right lane, and boom, I came to after a bunch of bangs.
I was muted. Darn it. Boomer Bull and Zoomer Bull are on a hill looking at a herd of heifers. Zoomer Bull says, let's run down there and hump a heifer. Boomer Bull says, I'm going to walk down the hill and hump all the heifers. Okay, call me Boomer again, Peg Leg. Come on, 1v1 me and you. See if my right hook is a boomer. Well, wait, hold on a second. Boomers hit hard. I know. I've been hit by so many boomers. Guys, we're in a trial. Can you guys show some respect? So we're about to see the entire DUI process take place, including the ending, but not the sentencing.
My car's back here, so we'll walk back here, okay?
Right.
It's the one that's facing towards the King's Auto. He'll be back. He's okay.
Who are you speaking to there?
His father was yelling.
So the airbag hits you in the face.
At us from right away.
Is it,
from us. Like I said, he was acting.
You told the doctor you're feeling all right. Just
I don't remember what he was saying, but he said something. And I
Missed you, XJ. Saw you in comments though.
Yeah, when you stand there
in the video, he skipped.
Speaking of comments, a huge shout out to B24 Liberator. Thank you so much. I appreciate it. Love your comments so much. You've been with me since the very beginning. And every time you put a comment in, my face glows. Thank you.
You're gonna have to stay on the other side.
I'm sorry, I paused there.
I apologize. Sorry.
That was my fault. Go ahead and finish what you were saying. You were interacting.
Earlier, we skipped over this part of the video.
Twice?
I had interaction with his father at the right-of-way fence. He told me, hey, I'm his dad. I says, okay, we'll take care of him. Don't worry about it. So I knew that it was his father yelling at us as we exited the... We'll be back. Apologize for talking over the video.
DUI, unalive, other driver.
So the airbag hits you in the face. Yeah. Is it? You told the doctor you're feeling all right, just a little lightheaded.
Yeah, when you stand up, you're gonna feel a little weird.
Jim, thank you.
You're gonna have a lot of adrenaline too. You're gonna hurt really bad tomorrow because right now you're not gonna feel anything because the adrenaline. And then yeah. All right. So like I said, I'm gonna put this in my car. Just have you stand in front of my car for me, would you please? All right, Sam. Can you sit on the hood of my car for me? Yep. Can you do me a favor? Can you take your hat either off or turn it around backwards, whichever one? Is the sun in your eyes? Yeah, a little bit. All right, we can go over here so the sun's not in your eyes.
All right, now we're going to see the field
You
test.
stand right there and just lean against my car. Helps the sun out.
I don't do a lot of body cams on this channel, hardly at all. I don't know why, I just don't. I do court cases. So we don't get to see these body cams. I know that you guys see a lot of them on other channels, especially Biggin, but I don't have time to watch Biggin. So body cam is like, ooh, shiny for me. We're going to see what you guys probably see all the time. We're going to see all of the sobriety tests that he fails. That he takes.
Your eyes now? Yep. Is that good? Yep. Okay. I'm going to ask you to do a couple of standardized field sobriety tests, like you said, just to make sure there's no impairment, all right? Yep. Can you take your fingers, interlace them like this, put them under your chin for me? All right. Now, can you see the tip of my pen right here? I can. All right. So I'm going to move my pen back and forth in front of your face. I just got to ask you a couple quick questions before we do that. Do you have any recent head injuries? I know you said your airbag hit you, but other than that, no. All right. Do you have any hard glass contacts in your eyes? Are you diabetic or epileptic? Nope. Do you have cataracts or glaucoma? Nope. All right. Can you see my pen? Yes, I can. All right. I'm gonna move it back and forth in front of your face. I need you to follow the tip of my pen.
That would be awesome.
With just your eyes, without moving your head. So I want you to keep your chin still and just follow my pen with your eyes. Can you do that? Yep. All right. Right here for me. Ready? Yep.
Micah is very busy tonight.
All right. So you're doing good. I want you to keep doing what you're doing. Just keep following my pen. Okay? Yep. Ready? I'm gonna hold it out to the side. Just keep looking at it, okay? Try to look at the tip for me. There you go. All right. Stay up at the tip, all right? Same thing over here, okay? Try to keep your head still. I know it's hard. Just try not to turn your head, okay? Just keep your head still. Follow my pen for me, all right?
No, he's very, very busy. I just said that.
All right. Try to stay up at the tip. You're doing a good job. All right, we'll go really slow this time, okay? You're doing a good job. Just keep doing what you're doing. Just try to stay at the tip, okay?
No, you're very, very busy.
You see the tip?
No one listens to me.
Okay, don't look away from the tip, okay?
I will drive you home.
Just one more time on each side, okay?
Yep. That's hot.
Last time on this side, okay? All right, I'm gonna go up. I just need you to follow it up without lifting your chin up. So keep your chin down and follow it up with your eyes. Can you do that for me? Yep. All right, right here for me. Ready? Still see it?
Yes, I am. Well,
Yes,
one more
perfect.
time for me, all right? This will be the last time we're gonna do that. Okay, so ready for me? Follow it up. So what I'm gonna do? I'm gonna make a couple small circles around your face and coming towards your nose. I'm just gonna check to make sure your eyes converge. Okay. You don't have to do anything other than follow my pen, and I'm gonna bring my pen in close to the bridge of your nose, but I'm not gonna touch your nose. Okay. I'm just gonna bring it in close. So I just need you to follow my pen. Can you do that for me? Yeah. All right. Same thing. The tip where the clicker's at. Follow it around for me. So follow it around. All right. Now.
I love you're seeing your daughter. I love that for you.
Follow it in. Follow it in. Follow it in. All right. We're gonna do that one more time. Okay. All right, so can you blink if you need to, and we're gonna do that one more time, right? Yeah, I know it's kind of a.
Yeah.
Did you have glasses on?
I did not, but I
It
will
looks like something poked you like glass, like maybe you had sunglasses.
What? Legal. You walk in the chat room and you are far above all the rest of us, and you like look down on us. You you are not blended in. You are like overlord. You are the overlord of the chat rooms.
The guy said he thought that, oh, I did have these on.
Yeah, that would be what poked you. Right. Yeah, they poked you.
Raven blends
As you
in.
can see where they.
Where it got, yeah.
All right, so I'm gonna do this one more time, okay? So that's fine where you're at. Just don't move your head for me. Follow within with your eyes without moving your head. So ready? So follow around for me. All right, now what I want you to do is follow it in towards the tip of your nose. Ready? Follow it in, follow it in, follow it in, follow it in. All right. That makes you feel weird. All right. I'm gonna ask you to do a couple more things. Like I said, this is standard field sobriety test. Okay.
Pause there. If you could tell the court, what were those tests that you just engaged in with the defendant?
The first part with the horizontal movements is called the horizontal gaze and nystagmus test.
I'm sorry.
3 tests that are prescribed by the standardized field sobriety testing manual. The vertical movements are vertical gaze and nystagmus. They're also part of that test.
I'm sorry, Jody.
Once I get done with those movements and I start making the circles, that's an A-ride test, or it's a different test for what's called lack of convergence.
Lori, get me your nurse's phone number. Get me her phone number. Bye, Lori.
You want me to explain the test or just tell you what I'm doing?
I think we watched the test. Is that correct? So
Yeah, you saw what was, yeah.
What were you observing, or what did you observe that would give you?
So during the horizontal gaze and nystagmus test, there's 6 clues, but 3 different parts. So I'm looking for a lack of smooth pursuit, which was present, a distinct and sustained nystagmus at maximum deviation, which I noted was present, and then onset of nystagmus prior to 45 degrees, which I noted was present. So I observed 6 out of the 6 clues. It's 3 parts, but in each eye, so 6 total clues. I did not observe a vertical gaze nystagmus. Vertical gaze
and nystagmus. Boomer walks into a Cadillac dealer. Salesperson asks, "Are you thinking about buying a Cadillac today?" Boomer says, "Nope. I know I'm buying a Cadillac today. I'm thinking about sex." Do they though? They only think about complaining. I'm thinking about complaining about sex.
nystagmus indicates what we call a high dosage for an individual. So not seeing it doesn't mean that the individual is not impaired. It just means that the dosage that individual or the amount of the drug or the alcohol that's in that individual was not a high dose for that person. So had I observed a vertical gaze nystagmus, I would have said that whatever was causing the nystagmus would have been in a high dose for that individual. It's not, it's for the individual. Did not see a vertical gaze nystagmus. Then I did the lack of convergence test. As you saw, I'm looking for the eyes to converge equally on the stimulus, which in this case is my pen. In the case of the defendant, his left eye converged and his right eye did not, so lack of convergence was observed. Lack of convergence is associated with several different drug categories. There is a small percentage of the population that can't cross their eyes naturally, but when you do observe lack of convergence, this can be used as an indicator that drugs or alcohol are present.
You then proceed with additional tests. Is that correct?
Yes, sir. Is there anything wrong with your feet, your knees, or your back that would keep you from being able to walk in a straight line and maintain your balance?
I have a torn ACL on my left knee, but usually it's...
Okay. When did this happen?
2-3 years ago.
Gotcha. You just never got it fixed? Okay. Did the doctor... So you've been functioning for 2 years with it torn,
yeah.
No problems?
I was about to go play golf, yeah.
Okay, all right. So clearly it's not an issue for your walking abilities. All right. So what I'm going to have you do, we got a nice line right here. Can you take a half a step forward away from my car? All right. So I'm going to put you in what we call the starting position. Then I'm going to explain what I want you to do. I'm going to show it to you so you know what it looks like, and then I'll have you do it, all right? So right now what I'm going to do, I'm going to put you in the starting position. So I want you to put your left foot on that yellow line for me. Put your right foot in front of your left foot with the heel of your right foot touching the toe of your left foot, and then just put your hands down by your side. Are you comfortable to do it in those shoes? It's up to you.
I'd rather do it probably barefoot.
That's perfectly fine, no worries. So go ahead and put your left foot on the line, right foot in front of your left foot with the heel of your right foot touching the toe of your left foot, and then put your hands down by your sides. Now, like I said, I'm going to demonstrate the test and show you what it looks like. I want you to stay in that position and don't move from that position until I tell you to begin, okay? So can you get back in that position? All right, now don't move from that position until I tell you to. Do you understand? All right. So when I tell you to, I want you to take 9 heel-to-toe steps down this line. I want you to turn around the way I'm going to show you and take 9 heel-to-toe steps back. It's going to look just like this. 1, 2, 3, and so on until 9. When you get to 9, leave your front foot on the line. With your back foot, take a series of small steps to turn around, just like this. And then take 9 heel-to-toe steps back down the line. 1, 2.
He already called
3,
his lawyer.
and so on until 9.
As soon as he spoke to him inside the ambulance, he said, "Can I call my lawyer?" Oh, wait. Nope. Hold on. Never
I
mind.
took 3 steps for demonstration purposes, okay? I need you to take 9 steps during the test. As you do it, make sure you look down at your feet. Make sure you touch heel to toe. Make sure you keep your hands down by your sides. And make sure you count your steps out loud.
First verse or second?
Once you get started, don't stop until you've completed the test. Does that make sense? Yep. Do you have any questions about what I'm asking you to do?
Nope.
All right. You're back in the starting position. Your first step from there will be number 1, okay? So go ahead and begin when you're ready.
1, 2, 3, 4, 5, 6, 7, 8, 9. And then you said 3 slow ones and turn around?
Yeah, the way I showed you.
1, 2, 3, 4, 5, 6, 7, 8.
All right. For this one, you probably want to leave your shoes off too. This is the last.
So that was the walk and turn test.
Yes, yes.
Tell us what you're observing there with regard to the defendant or any indications of impairment from that particular test.
So there are standardized clues for this one, just like for the horizontal gaze and nystagmus test. Observed several clues during the video. Moved his feet during the instructions. Stepped offline. Failed to touch heel to toe. Improperly turning, incorrect turn, stopping while walking. Those are all the ones that I saw in the video just now. In my narrative, I document which steps specifically, and I describe them better, but as I watch the video now, just off the top of my head, those are the ones that I saw.
But it's all pretty much reflected what you observed on the video, is that correct?
Yes. So when I write my statement,
We never get
make
to
it very
see them
detailed,
here.
which step, what direction he stepped offline and such. And I use this video as well as my cruiser video to ensure that my statement is accurate. But yeah, it's in much greater detail in my statement.
So again, there were clues of impairment during this testing of the
Yes. To the standard test, okay? Can you just take a step away from your shoes, like towards me, or on the, yeah, that's fine. That's right, that's good right there, perfect. You put your feet together, heels and toes touching, put your hands down by your sides. This is just like the last one. I'm gonna show you what I want you to do. I'm gonna explain it to you, and then I'll tell you when to begin. So I need you to stay like this until I tell you to, okay?
Yep.
You understand? Yep. I'm gonna take a step over here so I don't kick you when I raise my foot up, all right? So just stay where you're at. Yep. All right, so when I tell you to, I'm gonna have you raise your right or your left leg, whichever one you're more comfortable with, okay? So if your left leg's your bad one, you don't have to stand on that one. You can pick whichever one is good for you.
Sir, can I pick your leg?
I'm gonna stand on my left one, okay? So when I tell you to, I want you to raise your foot 6 inches off the ground. I want you to hold it parallel to the ground like my foot is right now. I want you to look down at your elevated foot, and I want you to count out loud in the following manner: 1001, 1002, 1003, and so on, okay? As you do it, I want you to make sure you look at your foot, make sure you count out loud. Make sure you keep your hands down by your sides. Make sure you keep your legs straight and rigid. So I don't want you to bend your knees. I want you to raise your foot up towards the sky. I don't want you to point it down. I want it parallel to the ground, okay? Yep. And then, like I said, keep it 6 inches from the ground and make sure you count out loud. Make sure you look at your foot, okay?
And go to 1,000.
So it's a 30-second test. I'm going to tell you when it's over. You just keep going until I tell you it's done, okay? Does that make sense? Yep. All right. Do you have any questions about what I'm asking you to do?
Is he going to last 30
So if
seconds,
you don't have any
guys?
questions, whenever you're ready, you can begin, and I'll tell you when it's over, all right? So go ahead and begin when you're ready, all right?
1,000, 2, 1,000, 3, 1,000, 4, 1,000.
6 inches for me, okay? So just a little higher. There you go.
5, 1,000, 6, 1,000, 7, 1,000, 8, 1,000, 9, 1,000, 10, 1,000, 11, 1,000, 12, 1,000, 13, 1,000, 14, 1,000, 15, 1,000, 16, 1,000, 17, 1,000, 18, 1,000, 19, 1,000.
All right, that is 30 seconds. You can stop.
Go ahead and put your foot down. All right, we can come back here. You can put your shoes on if you want. So I'm gonna actually do some.
Referring to that test, what are you observing? What are you looking for? What did you see? If there were any indications of impairment during there?
So there are standardized clues with this test, just as with the other ones. In particular, on this one, I made more observations than I observed standardized clues. I very clearly instructed him several times to lift his foot 6 inches off the ground. He didn't. I had to advise him during the test to make sure that his foot was 6 inches off the ground.
Sir, that could be 6 inches to him. You don't know him.
During the test, he had his hands in his pockets. That is a pretty common thing that people will do to keep from raising their arms. I did not tell him.
I'll overrule the objection. Go ahead.
I did not tell him to take his hands out of his pockets during the test, so I observed that he had his hands in his pockets. Something that we will look for, again, it's an observation. This isn't a standardized clue, but it's an observation that during the test, I gave him 30 seconds on my watch. He only counted to 20. So there's a difference in time, obviously, his counting versus what actual time is. So I'm seeing that his spatial awareness, his time, his internal clock might be off a little bit. As far as observations go, those are the observations that I was making during that test.
So those were so you're making a distinction between observations that gave you some indication of some concerns for his ability to operate unimpaired, correct?
That's correct. So,
but
yes, sir.
But there are, with regard to that test, there are actually clues that you're looking for as well.
Yes, sir. There are standardized clues that were standardized during a study, and then there are also observations that I made as a DRE, as an ARIDE trained officer, that lead me to believe that there is impairment, possibly other drugs on board. In this particular case, not based on the fact that the standardized clues, outside of the standardized clues, there are observations that I made through my training experience lead me to believe that he's impaired.
But he didn't have any standardized clues.
I did not observe any standardized clues per the manual.
Extra different things. You said you take Klonopin? Yeah. Okay. All right. So what I want you to do, where you're at, with your feet together, heels and toes touching, just keep your hands down by your side. So this one's a little different. What I'm going to do is I'm going to give you the command to tilt your head back, close your eyes, and begin. Okay. And when I give you that command, I want you to tilt your head back, close your eyes, and I want you to tell me when 30 seconds is going by. Okay. I don't want you to count out loud. But however you get to 30 seconds, once 30 seconds is going by, I want you to tilt your head up, look at me, and say stop. Does that make sense? Yep. So one more time, I'm going to give you the command. Hold on, one more time. I'm going to give you the command, tilt your head back, close your eyes, and begin. So once I do that, you're going to tilt your head back, you're going to close your eyes, and you're going to tell me when 30 seconds has passed, okay? Yep. Once 30 seconds has passed, I want you to look at me and tell me to stop. And I'm going to see.
Safe word is stop. Got it.
All right. Do you have any questions about what I'm asking you to do? All right. Go ahead and tilt your head back, close your eyes, and begin, okay? The instructions. Was that time? Okay, sorry. All right. Do you remember I told you to look at me and say stop? That's what I was waiting for.
I apologize. When I leaned my head forward.
That was when. Okay. All right. How long do you think that was?
28 to 30 seconds.
I do that too. I do it all the time.
25. Okay. So I'm gonna ask you a question. Did you?
So tell us about that testing. What are the standardized clues you're looking for?
Yes, tell me about that test, guys. Driftwood did it in 20 seconds. Overachiever. How far did you guys get?
Did you observe any in that particular instance?
So there's not really a standardized clue. There is a deviation from the time that the vast majority of people will fall within plus or minus 5 seconds. Anything outside of that is considered to be outside of the standard for a normal person. As far as my observations that I made during the test, I did observe eyelid tremors while he was performing the test. Eyelid tremors are very commonly associated with the drug.
All you had to do is close your eyes and count security. You can do that.
Category cannabis, which is marijuana. There are other categories that can cause eyelid tremors, but it's very
Good job,
commonly
Adam.
associated and very, very prominent in the drug category cannabis. Another thing that I noticed, and it's pretty striking when you watch it right in front of you like this. He forgot the instructions in the test. I gave them to him twice. He said he understood them. He was very clear about the instructions. When you feel that the 30 seconds has passed, look at me and tell me to stop. And by my count, when I did this, it was 25 seconds, and he opens his eyes and stares at me very vividly, which was not how he was instructed. And I prompted
I'm gonna need your keys, sir.
instructions. And
Sorry,
he
but I
just
need
stared
your
at me and
keys.
he looked confused. I was like, was that time? So, in my perception as an officer on scene, that to me is a big indication that his divided attention skills are not very with it, or very impaired, because he can't follow the directions. He's staring at me like, hey, I did what you told me to do, but forgot the instructions. So these are all divided attention tests. And what I'm looking for is impairment in his divided attention, his inability to follow the instructions, remember the instructions, perform the test as instructed.
I need
So
it. It's
not only
medicinal.
are we looking, how fast or how slow was he? We're looking for things that he can't control, like eyelid tremors. He's no control over that. And we're looking at, did he perform the test as I instructed him? Did he forget the instructions? These are all things that I'm observing and that I'm making note of as I'm going through the tests.
You have anything to drink last night? I did around probably 8 or 5 p.m. Okay, yeah. It can still smell the odor coming from your breath, okay? What I'm going to do, I don't think you're, here's where I'm at, okay? I can smell it coming off you, and I saw some clues in your...
There's one part you guys missed because I completely cut it out. This driving was in the middle of the day on Palm Sunday. He's going 125 miles an hour down this busy highway.
Field test. What I'm going to ask you to do is take what's called a portable breath test. It's going to tell us where your alcohol level is since you drank, at 8 o'clock last night. Yeah. That's the last when you had the last drink. Yeah, probably 10 o'clock. Maybe. 10 o'clock.
And I
Okay,
take
yeah,
their
so it's
keys
been
all the
12
time.
Hours, 13 hours at this point. So I'm going to ask you to blow in the machine just to make sure there's no alcohol on board. Are you willing to take a portable breath test? Can I call my lawyer? Yeah, we can do that. Do you have your phone with you? I do. All right. Why don't you have a seat here, and I'm going to let you make your call, okay? Yeah, thanks.
He has absolutely no regard for the life of anybody else anywhere on the road. None. Zero regard for anybody's life.
He did not wish to provide any chemical tests. I asked him for both a breath test and a urine test. He refused them, and then we proceeded with our preparations for the warrant.
And so you were able to obtain a search warrant from
Sometimes
the,
I get a lot of
Department
keys.
Police to obtain a sample of the defendant's blood.
Yes, we did obtain a warrant signed by a judge. We executed that warrant after obtaining.
Around 1:47 p.m., did you transport the defendant to the Bethesda Arrow Springs Hospital to obtain that blood draw?
I did.
Did you take anything with you to facilitate that procedure?
I believe I had a Ohio State Highway Patrol kit. It's a urine and blood combined kit. It has all the necessary things to do both a urine test and a blood test.
Peg leg, I'm going to say that you absolutely can lift your foot off the ground. I'm just going out there on a limb to say that you can stand on one leg.
You received those blood and drug results, correct?
I did, yes.
And did they indicate that the defendant was over the legal limit for both a concentration of marijuana and marijuana metabolite in his blood?
Yes.
All right, we're back on the record in Mr. Sperry's case for closing arguments. Mr. Hardman?
Thank you, Your Honor.
Okay, we skipped all the rest of the lawyer talk and the victims. Oh gosh, the victim's family. I'm telling you guys, don't drink and drive. Never, not even once. Just don't. So here we're going to hear the closing arguments. Okay. His lawyer, everybody's going to get mad at his lawyer. And, I get it. I get it. But he does a really good job. He just does. That's his job. I love when people are good at their jobs, even if their jobs are shitty.
I want to start, I guess, backwards a little bit. With counts 5, 6, and 7, which are the OVIs.
Very
If there's
carefully.
really any question that we've heard from the evidence of this case that beyond a reasonable doubt the state's proved on April 2nd, 2023, the defendant was driving impaired over the limit for marijuana and marijuana metabolite, over it by 5 to 6 to 7 times the legal limit.
Unalive.
So then we get to the crash and how he caused this crash into 76-year-old Shirley Coletta and her daughter Patty Jump. What we know is that at 1.5 seconds before this collision, there is 107.75
I love your boss.
between these two cars. Almost 8 car lengths between where Miss Coletta was and where the defendant was. We know from the witnesses we know from the witness, Mr. Kirk, who's coming onto the highway, that he sees Shirley Coletta's car with a turn signal, notifying the person in the left lane that a lane change is about to happen. We know from the video itself that there's at least 1.39 seconds by the defendant's own expert. I would suggest, as the court looks at that, there's slightly more from the time she starts making that lane change to where the collision actually occurs. But just accept their expert's 1.39 seconds. We know that in that period of time, the defendant had to travel over 250 feet, which wasn't enough time for somebody driving 124 miles per hour, with heedless indifference to anybody else that was around him. Heedless indifference to the consequences of operating that car and the type of conditions that existed that morning on Sunday at 11 o'clock in the morning. Well, under the influence of marijuana, with clonazepam in the system, with alcohol in the
Means
system,
he's in the right place.
Heightening the effect of all those drugs. But we know that someone driving 110 miles per hour, just by doing the math, would have taken them over 1.5 seconds to close that 252-foot gap beyond the normal perception response time. We know someone driving 105 miles per hour would have taken them 1.64 seconds to close that 252.795 feet to the collision.
I agree.
The 1.5 to 1.6. You have to get all the way. I mean, it is clear that the defendant's reckless behavior that day, the effects of the drugs on his system, and you heard from Bob Topmiller what those effects are. The effects of the marijuana alone would cause his cognitive ability.
Marijuana, cocaine, alcohol, 125 miles an hour in the middle of the day, Palm Sunday.
To not be functioning. He'd have a lack of concentration. He'd have altered time and space perception, disorientation. His processing visual information was done more slowly. It decreases his ability to shift attention to what is going on. All of those things were going on just from the marijuana itself, much less the heightened effects from also the alcohol and the clonazepam, as Mr. Topmiller testified to this court. The burden of the state is to prove that the defendant was one of these causes, but for the defendant's actions that day, reckless actions, and his impairment as a result of drugs and alcohol, this crash would not have occurred. I would submit the simple fact that in 5 seconds we know, and even beyond that we know, he was going over 100, at least in the 5 seconds we know he was going over 120 miles per hour. He never would have even been in that location to be able to cause these injuries, this death to Shirley Coletta, and the injuries to Patricia Jones. his inability to perceive the danger that he was posing to the public, the risk. I mean, it was clear to the two individuals, Sean Gabbard and Michael Kirk, who were in a better position to see how the defendant's driving behaviors were taking place that day than, unfortunately, Shirley Coletta, who made it very clear to this court they feared for the safety of the people on the road that day because of what they observed this defendant doing. I think the evidence shows, the gathered evidence, that it was both because of his impairment and because of his recklessness that we are here with a dead 76-year-old woman and a woman whose life has been totally altered, but clearly caused serious physical harm by this collision on April 2nd.
Okay, now we hear his lawyer.
Your Honor, I know that you have reviewed the expert opinion in this case
I'm Dungeon Master.
in great detail. And in addition to that, you've listened to me argue my case in my Rule 29 motion. So I'm not going to repeat myself. Other than to indicate the following. Mr. Hartman wants to focus on the number 250 feet or 125 feet, whatever his number is that he's talking about, feet. And I would focus instead on the figure of 1.5 seconds. Because that, after all, is what we're really talking about. Whether Mr. Sperry had time to react to the undisputed lane change.
It should be fine.
Mrs. Coletta. Mr. Hartman's calculation and argument does not take into consideration.
I can't make it louder.
1,001, 1,000, this second and a half. It's not a situation where Mrs. Coletta has gone 2/3 into the lane and is there, and Mr. Sperry sees her and strikes her. This is a situation that's dynamic, that's occurring as the cars are going up the road. It is somewhat a different analysis, but in any event, what I would indicate to the court is essentially what I indicated in my Rule 29 motion. Number one, the state is arguing that they have proven that impairment was the proximate cause of this accident. And I would suggest to the court that if in fact that were true, it is something that
I will look today, Casey.
From the witness stand. Mr. Topmiller indicated to you, frankly, that his analysis of this was based upon a set of assumptions. And as he indicated, they were assumptions that he couldn't even say were accurate. In particular, he refuted at least part of what my client's statement to the police had been when he indicated he did not believe that he believed the consumption of marijuana had been somewhat immediate and could not discount the fact that the alcohol was somewhat immediate. And if in fact those two things are true, then his analysis of what the marijuana would have been in my client's system and his analysis of what the alcohol levels would have been is faulty. But that said, the important thing is he indicated that he was unable to attribute impairment as a cause of this accident. He actually indicated he didn't know what the cause of the accident was, that wasn't his expertise and was not in a position to make an opinion. We then moved to Trooper Gupta, who gave a recitation on the
I'm so
on his
sorry.
findings, and the court permitted him to testify, even though it wasn't, permitted him to testify that he thought that my client was impaired. But most importantly, even when you read his report does not say that the impairment was the proximate cause of this accident. And then we come to Officer Krantz, and perhaps more importantly, he is the state's accident reconstruction specialist that the court is to rely on to make a determination of what the cause of this accident in fact was. He's had every opportunity to say that he thought it was as a result of, or included in his report, I should say, that he thought that it was through impairment or other things. He clearly said in his report, and only said, that he thought the cause of the accident, which was failure to keep insured clear distance, which he didn't say that it was reckless operation of a motor vehicle. He didn't say that it was the excessive speed. He said it was failure to keep insured clear distance. Now, he tried to testify, and Mr. Hartman tried to, and I don't mean that critically, but ask questions in an effort to try to get Trooper Krantz to give an opinion as to whether alcohol played a role in this or drug, or to give an opinion as to whether he thought the conduct here was reckless. On one hand, he gave the answer before anyone knew what the answer was going to be, and the court, I believe correctly, struck that answer from the record and indicated, no, it's not in your report, I'm striking that from the record. When he then tried to testify about recklessness, which was outside his report, you sustained the objection and did not let him testify as to that, and I think properly. So that leaves us with his report, which indicates that he believes that the cause of this accident was my client's failure to keep insured clear distance. And that is a minor misdemeanor traffic violation in the state of Ohio. I mean, it's what it is. I can't help that. It is what it is. And if in fact this accident was caused by the commission of a minor misdemeanor traffic violation, then my client's guilty of manslaughter, vehicular manslaughter is what he's guilty of. That would be, assuming that's correct, that would be the law. Our expert opinion, which I'm certain that you've gone through in great detail, actually determined that, in his opinion, it stands here unchallenged. In his opinion, that the cause of the accident was Mrs. Coletta's, the manner in which that she made her lane change. And in his analysis, he indicated that given this 1.5 second, you've read it, about what perception about these different things, that he wouldn't have had an opportunity to react to that in time. And that report stands unchallenged, as does Trooper Krantz's. For the most part, they are pretty much lockstep with one another, but there are differences. But nowhere has the state refuted my client or my expert's opinion on how this accident actually occurred. They had every opportunity to let Trooper Krantz review his report. They had every opportunity to let Trooper Krantz prepare a report, either critical or or disputing what our experts said, and they didn't do that. And so I have to assume fairly that the only reason he didn't do it is because he's in agreement with it. He has no quarrel with what's said. And if you take my expert's opinion based upon those things, it paints a completely different picture of how this accident occurred. And I would indicate again the question, and Mr. Hartman has framed his question in terms of my client, Mrs. Flood starting her turn at 2.5 seconds before the collision. The 1.5 seconds, 1.5 seconds is the key.
He's not allowed to do that. He has to listen.
Our expert says when he talks about reaction time, how much time you have to see it, then how much time you have to make a decision, and then move your foot to a brake, and that under any set of circumstances, if a person is not impaired, it takes that 1.5, would take at least 1.5 seconds. But the most important thing here, Your Honor, like all cases, is the question of who has the burden of proof. Does the state of Ohio have to prove that my client is guilty of an offense?
I guess I should let you know. Okay. He's going 125 miles per hour down the highway in the passing lane, in the left lane. Okay. She, without looking properly, gets into the left lane. Now, you saw the video at the beginning. Should she have? Should she have gotten in the left lane? There was a car coming. She should have waited. She did get into the left lane when she should not have. Okay. She did that. She actually did that. That does not mean, okay, you'll hear more about what caused this accident. That really was part of it. She got over when she shouldn't have.
Do I have to prove that he's not guilty? We all know the answer to that. The state of Ohio has to prove each and every element of their case, as we all know, and they have to prove it beyond a reasonable doubt, which is the key here. I don't think that this is a simple case by any stretch of imagination. I don't think it's an easy decision for the court or anyone else to make. This is a tragic case. It's a difficult situation.
Not just
But it
speeding,
is what it is. And I would
125.
suggest to the court that the state of Ohio has failed to prove their case of what they allege, that impairment caused the accident, that recklessness caused the accident. The case they've made is that his failure to keep insured clear distance, if you accept that, independent of what my expert says, is a misdemeanor. It carries certain penalties. And that's really where we are, and that's really the state of the evidence. I only would again emphasize to Your Honor that in cases where you have issues, which are beyond
100%.
common understanding, like
100%.
reconstruction, you have to rely on not only what the experts say,
Yes, but not the
but what they don't
sentence.
say. And what they have not said here, any expert,
It's not
is that alcohol or
125.
drugs was a contributing factor to this accident, that but for those, this would not have.
Then stay out of the left lane.
No one has given an opinion.
I can infer that, right, Mr. Crosswell? I mean, I can infer from the consumption of alcohol, the consumption of the marijuana, and the consumption of the clonazepam or whatever those are, those three factors, plus the rate of speed that he was traveling, I can infer from that set of facts that if not for drugs, alcohol, and speed, he would have seen this turn or this lane change or the signal, and he would have avoided the collision, right? I can infer all that, can't I? As long as I'm convinced beyond a reasonable doubt of the truth of that assertion.
Respectfully, and I mean it, I appreciate the
You don't have to keep saying respectfully.
Well,
We both know what that
I don't want to be
means.
argumentative. I don't want to appear to be.
I wouldn't have asked you the question if I didn't want an answer.
All right. Your Honor, I think the
Do
law
your
is
job.
clear that in order to make a determination of what the impact would have been here, you need expert testimony. You need testimony beyond just saying what Topnor said, that traditionally, in a generic term, here's how certain things impact people. He didn't even, his statement was, to some degree, it could be, 0 to 100. I can't begin even to say what degree, and I can't begin to say that it played a part in the accident. And I personally believe that when you're talking about accident reconstruction and the cause of the accident, that it does in fact require an expert opinion in that regard. So I do believe that. But in any event,
Can we all just agree with Barb here? Because the guy who got in this accident said that he was in the left lane because that's the through lane. That's where people drive when they're just, going through and they're not getting off any of the exits. And that's not correct. If you're in the left lane, you are the problem in this world. Get out of the left lane. Sorry. Thanks, Barb. Now you just got me in trouble.
I don't believe that even if you were to infer that.
Show off. Oh, 8 kilometers. Never
Under
mind.
these circumstances, considering that you have the state's witnesses who themselves say they can't say that, and it would seem to me logical to believe in a case like this that the reason that the experts are not saying that is because they're unable to say it. And if they're unable to say that that's the case, if they're unable to make that leap, if they're able to show that as a cause, then if the court infers something, the court still can't find beyond a reasonable doubt without some type of testimony that that's the case, especially considering the fact that we have a competing expert who sits here unchallenged.
Americans are ignorant. They just
And
are.
so I go back to this because I really am being critical of myself, because when I first heard about this case, I heard, oh wow, 125 miles an hour, alcohol and drugs, a rear-end conclusion, a rear-end collision. I started making all kinds of leaps too myself.
That
Well,
was
this
made
must be,
for
this
me.
must be, this
Oh,
must be.
oh.
And then when I started to read the reports and when I started to review the evidence, I thought, well, maybe I think it must be, but I don't really know, anything about it. I mean, I'm not an expert. I'm going to read what these folks say. I want to read what the state's witnesses have said here. And when I determined that what they were not saying was that alcohol was a contributing factor here, I had to assume, given the fact that I am impressed with.
Please, someone tell me how much that is. Can someone please tell me how much that is? Please, I'm not going to be able to sleep tonight until I know how fast you're allowed to drive in Australia. 110 kms an hour. 110 kms an hour. Is 68.3508 miles an hour. Okay, that's baby. That's not a lot. You need to up it up a bit.
And I think they're very professional. And I know that
Like
Kevin
the
is,
Autobahn.
that if in fact they believe that alcohol was a contributing factor here, they would
Peg
have
leg
said it.
again
But
for
they
the
didn't
win.
testify to it.
Dude.
And given that fact, I
Dude.
think it's only fair when the court is drawing inferences, it's only fair to draw a large inference that if they don't say it, it's because they can't say it. And let's just assume that they could have said it. Well, okay, so they could have, but if they didn't, that's where the
Now I
record
understand. Thank
that's
you.
the record we're dealing with. And I go back again and again and again to this argument that the state had every and if they had disagreed with my client's, my expert's opinion here, his report, Officer Krantz, who I'm sure reviewed it in great detail, could have prepared a report refuting what my expert said. That's what they would have done.
Is 200 grams half a pound? That sounds not right.
Because they accept what he's saying, and what he's saying clearly raises reasonable doubt, even as to
You should get tased.
causation of the accident. I mean, it raises doubt across the whole thing. And again, I have to believe that when the state read the report of Officer Krantz, Trooper Krantz, and Trooper Krantz said that the cause of this accident was a failure to keep insured clear business. I have to assume that they looked at that with a raised eyebrow, as did I, especially given the broad spectrum of allegations, and themselves questioned, well, he's saying that this
You
is
can't buy too much cheese.
distance,
It's not possible.
and he's not saying
It's like dividing by zero.
or that it's reckless. You see, these are terms of traffic violations. It's just not factual. They have not said that this accident occurred as a result of my client operating a vehicle in a reckless manner. They've not said that the speed in and of itself is reckless. As a matter of fact, the law is clear that the speed alone isn't reckless. I mean, I've not said that.
How you doing?
So what they've left you with is Rule 16K, I believe it is, on expert witnesses, which says that the experts can only testify on in relation to what's in their report. It's left you with the rules of evidence, which indicate that if a matter is beyond the normal expertise, you have to have an expert, and his testimony is confined to his report, and that's really the record that you have to decide this case on. And again, I think it's difficult. It's not a task I would like, But that's the reality. That's the record of evidence here. And frankly, as I said in my opening statement, I thought that this case would not only be about what was proven, but that it also would be what was not proven, what was left unproven. And while there's a tendency in cases like this, certainly I'm not sitting here to endorse my client's conduct in any fashion. And I accept the tragic nature of what occurred here. But as we all know, this is not, it's not a popularity contest. It's not what's right or wrong. It's what ultimately is proven in a court of law beyond a reasonable doubt. And I would respectfully suggest that.
See, he's trying. Like, no matter what, he's trying really hard. That lady got over she shouldn't have. That's one issue. And he's leaning on that issue as far as he can. And that's his job.
That I believe that an analysis of the two expert opinions, an analysis of the opinion itself, not just how they arrived at the opinion, but an analysis of the opinion. In other words, my opinion is this accident occurred as a result of Sperry failing to keep an assured clear distance. Period. End of story. And these are people who deal with alcohol all the time. They're people who deal with impairment. They're people who view accidents all the time. And there are people who say, yeah, this guy was impaired and that's what caused the accident. Every day. But that's not what they said here. And I would suggest to the court, in fairness to my client.
Hey, Fozzie. Hey, Fozzie. Do you want to go to Australia with me? See if they let us in.
The only thing a court can conclude, if they don't say it, is they're not saying it because they can't. And so with that in mind, I believe that the state has not proven beyond a reasonable doubt counts 1 and 3. I believe that counts 2 and 4 have not been proven to be reckless, that instead lesser included offenses at the most of vehicular homicide are appropriate findings here. And I would ask the court to rule for the. Thank you, sir.
Okay, I don't know what happened just there because there are 7 counts against this guy right now. 7. And I don't know what they all are. But he just said, I don't think they proved 1 and 3. And then he said, I don't think they proved 2 and 4. What happens with 5, 6, and 7? Just is this lawyer just saying, oh, I guess they're okay? Wait a second. The judge gets to talk now. If I press play and I stop talking.
Starman, you have about 5
He's
minutes
going to be
remaining.
quick. Don't worry.
Sergeant Kunka told you, Your Honor, that the defendant was impaired.
All he has to say is 125 miles an hour, cocaine, marijuana, alcohol, and drop the mic. That's all he has to say right here.
His driving ability was impaired based on what he observed that day and then ultimately confirmed through the testing that was done on the defendant's blood. That his ability to operate a motor vehicle was appreciably impaired on that particular day. You heard from Trooper Krantz what occurred with regard to this crash, how these cars interacted. The fact that
Mr. Harmon, I apologize for interrupting. Isn't your argument on this a little bit circular where there was a crash, Mr. Sperry had ingested drugs and alcohol.
My heart tells me how to make
Therefore,
drinks.
The drugs and alcohol were the proximate cause of the crash.
Well, it's part of the argument, sure. I mean, because you have a crash, you know the defendant engaged in the crash, he caused the crash at that point in time, and he was under the influence. We know that the drugs that he was under the influences that were impairing his ability to operate the motor vehicle cause certain behaviors to take place. That's the purpose of having Robert Tutmiller here to talk about what the level of this marijuana and then the heightened level is.
My boss My boss tried to bring a jigger into the bar. I don't know, like 2 or 3 weeks ago. A jigger is a little measurement cup you see in bars. You've seen them before. They're silver. You pour the liquor in there and then you pour it in the cup. My boss tried to bring a jigger into work and told me and the other server, Jess, we have to start using a jigger when we're pouring drinks. And I said, no, I'm not. No, I'm not. And he says, "Yeah, you have to because you're overpouring." I said, "No, I'm not. I've never overpoured. I don't overpour." So I pull out this great big gigantic glass. All right. My other server, Jessica, she pulls out this great big gigantic glass, and we both pick up a bottle of liquor, and we both pour it into this great, each of our own great big gigantic glasses. And then we both poured our liquor into his little jigger, and it was perfect. Perfect. Our measurements were perfect. I told him I'm not using that jigger, and he can't make me use that jigger. I don't overpour.
Marijuana with the clonazepam and the alcohol, what that does, and I think he told you, and talk about being unchallenged, made it very clear that his behaviors, that these drugs would interfere with his cognitive abilities, are part of what caused this crash. His ability to realize and appreciate the fact that driving 124 miles per hour down the street
I don't have time for that.
on this Sunday morning was an
Oh, Fozzie, you're getting very close to the joke that guy made tonight that ripped him right away from the jaws of victory into the jaws of defeat.
and was likely to cause the type of consequences that existed here. But I think what's also important, there's been this conversation about Mr. Gildersleeve being unchallenged, and I don't think that's the case at all. I think I made it very clear what we challenged. We challenged the fact that, by his own admission, there was 8
Exactly, BI.
between
Exactly.
Shirley Coletta and the defendant at the time, at 1.5 seconds before this collision, which would clearly be based on the evidence of the video that was seen, based on the witnesses talking
Buenos
about
dias.
putting on a turn signal, clearly enough time for anyone to successfully make a lane change, but for the fact the defendant is driving recklessly with the amount of drugs that were impacting his cognitive abilities on that particular day and on that time. But separate and apart from that, the other challenge was the fact that we know that the defendant had to travel 252.795 miles if you accept.
Absolutely.
But there was 1.39 seconds when someone would be able to perceive when the crash occurred. And anyone driving less than 120 miles per hour, anyone going 110 miles per hour
Buenos dias.
would have the 1.5 seconds of perception and response time in order to avoid this collision from happening. So that just shows that it was because of his reckless behavior, because of those decisions, those poor decisions that were being made because of the level of alcohol, marijuana, clonazepam that was in his system on that particular day, that was causing him to behave in this reckless manner. And we would ask the defendant be found guilty.
You're very tired.
There's a lot of this case that is not in dispute.
Judge Scheim.
The defendant was operating a motor vehicle on April the 2nd, 2023, Warren County, Ohio. That's the defendant there sitting at counsel table. There was a motor vehicle collision. The motor vehicle collision resulted in the death of Shirley Coletta, resulted in serious physical harm to Patricia Jump. At the time of the collision, the defendant had ingested some amount of alcohol, some amount of marijuana, some amount of clonazepam. There was also some reference in the report about cocaine, but that was not relevant in any way to my determination. It's intensely ironic to me that in 2024, we almost take for granted and set aside the fact that this collision was captured on video. There's a video of it. And not only do we have a video of the collision, we have a video because of the advances in technology and sort of better thinking on everybody's part these days. We have evidence of Mr. Speary's behavior, demeanor, following the collision, his interactions. 10 years ago, we would have never had this type of evidence in a case.
I
like
do
this.
too.
The issue
Then I
in this
married
case,
him.
aside from the facts, is whether or not his behavior was the proximate result, i.e. the proximate cause of the collision. I don't need an expert witness to tell me how I should decide the ultimate issue in the case. Trooper Kunka testified that the defendant was impaired, but with all due respect to the trooper, had there been an objection to that testimony, I would not have permitted it. Because I think what is evident from the facts, is that there were 3 causes of this collision. And by cause, I mean an act in the natural and continuous sequence directly produced the death of Ms. Coletta and directly produced the serious physical harm to Ms. Jump. And these causes are the high rate of speed for Mr. Sperry, the lane change by Ms. Coletta, and the drug and alcohol consumption by Mr. Sperry. In the absence of any of these 3 circumstances, this collision does not occur. And the lane change was signaled. Ms. Coletta signaled her intent to change lanes. I don't know if that was a useless gesture given the speed involved in
Yes,
this.
at the beginning, I show the video.
But it is not reasonably foreseeable to her that some would be approaching her in the fast lane at 124 miles an hour, approximately twice the legal limit for this area. So even though the lane change was a cause of the collision in the strictest sense of the word, her actions from a legal perspective were not the proximate cause of the wreck. The primary proximate cause of the collision was Mr. Sperry, your excessive speed was reckless, was irresponsible. It was conducted with a heedless indifference to the consequences. The risk is that someone is going to pull out in front of you, that there is going to be something that happens that you don't have the ability to compensate for, that something would happen.
Absolutely. Absolutely.
There's an infinite number of possibilities that could have happened. These are the dangers associated with speed. That's why we limit the speed that people can go. Sometimes it's 70, sometimes it's 65. It goes down to 20 because we have a lot more risks in the 20-mile-an-hour zones than we do in the 75. We disregarded this risk, and that's why this collision occurred. Your responsibility is not limited to the immediate and most obvious result of your actions. You're also responsible for the natural and foreseeable consequences that follow in the ordinary course of events from those acts. Additionally, Mr. Sperry, you were under the influence of alcohol and drugs at the time of this collision. Combined effects of alcohol and drugs noticeably impaired your ability to act, react, and make decisions. And you can see this impairment in your behavior following the collision from your appearance, your verbal responses to the questions that were presented to you, my observations, not what somebody tells me, but my observations of the field sobriety tests. They tell me that your use of drug and alcohol deprived you of that clearness of intellect and ability to make decisions that you would have otherwise had if you had not used drugs or alcohol.
Only partly.
That's a complicated and lawyer-like way of saying, Mr. Sperry, that you were at fault for this wreck. Ms. Coletta, certainly not Mrs. Jump, or not. They bear no responsibility for what happened that day or for the result. The law does not permit a person to travel at this rate of speed after having ingested alcohol, marijuana, and some other prescription drugs to point to the other driver's actions as foreseeable as those are as the cause. I also find that you were above the legal limits for both marijuana and marijuana metabolites. And I find that the state has proven beyond a reasonable doubt all the essential elements of all 7 counts of the indictment. And I find you guilty of each and every one of those.
Okay. So we don't get to sentencing today. We'll get to that in a second. But keep in mind, the judge just found him guilty of all 7 charges. All 7. So that'll give you an idea of how he's thinking when we get to sentencing.
Charges. We need to set this matter for sentencing. I assume to do a pre-sentence investigation, or does somebody want to go to sentencing today?
No, we'd like a pre-sentence trial.
All right, so we will conduct a level 2 pre-sentence investigation. I'm not going to make any changes to bail pending the sentencing, and we will hear back from everybody in about 6 to 8 weeks. Anything else from the state?
6 to 8 weeks. And I'm sorry, I don't know what bail is. I don't know if he's bailed out. I don't know if he's in custody. No one knows. I don't know.
No, Your Honor, thank you.
Anything else from the defense?
Thank you. You'll notify us of the date.
Ms. Idle will reach out to you to get a date. Mr. Speary, you need to go down to pretrial services and check in with them today. I don't know if they have time yet today. to
Oh,
fill
he's
the
out on
paperwork
bail.
for the PSI, but that's something that needs to happen.
Thank you, sir.
Anything else we need to do today?
No, thank you.
Thanks, sir. All right. What
That
I'm gonna
man
do
is
I'm gonna let
going
folks
to
on this side of
jail.
the gallery remain seated and wait. All of you folks will have the opportunity to follow Ms. Brown clear out so that we don't have any issues in the hallway or in the lobby. Mr. Hardman, you will send me.
That man is going to jail, guys.
Or do I do my own?
Yes, we'll take care of it.
Okay. All right. Anything else from the state?
No, sir.
Anything else from the defense? All right, that's all.
I agree.
Do you have
Muted. Muted. Okay, let's adjust the elephant in the room. No Judge Fleischer today. Judge Fleischer's baby is sick and he didn't have a babysitter. Although his wife is a nurse. So I'm just saying, I'm not a nurse. And I would be a terrible nurse, let me tell you. Quit crying and get back to work is all I would say every single day. But maybe she should be watching the baby because she's a nurse and the baby's sick. JK. It's hard to say JK because I think I don't know if I'm allowed to say this. I think about JK Rowling, even though everybody hates her right now, but I love Harry Potter and I always will. Anyway, Judge Fleischer was not in court today. And, just for the record, I can't prove this. There's nothing I can do to prove this, but I was ready to be on time today. I am never on time today, and I'm a mod, and I was there. I was ready. I couldn't sleep. I was tossing and turning. I had it open. I had it ready. Oh, man, which is just sad because I just make Maiko and Linus do all the work. I mean, I get, all right, so I did all the work, and now that there's more mods, I'm sort of like taking a break from Judge Fleischer, but I still make them do all the work. Used to be me and Michael doesn't come at all anymore. He comes in here every once in a while. Victoria, I'm talking about your husband, who is totally obsessed with you. You know that. Maybe Judge Fleischer will be in today. I'm actually sure of it. I'm pretty sure Judge Fleischer is in today. I'm not going to try to stream while Judge Fleischer is on because I'm a mod and I'm supposed to be there. So after Judge Fleischer is over, there she is. I love her. After Judge Fleischer is over, I'm going to start streaming in the members only section of my channel. So you would go to my channel. If you're a member, you would go to my channel. And I hate that. I should change that. You would go to videos. And actually, this is going to be live. My bad. It'll be live, but it'll say for members only. And then later, if you want to see it later after the live is over, then you would go to videos and it'll have this like green star by it. And if you watch videos in members only, they're not appropriate. I'm just letting you know now. They're not appropriate. Okay, hold on. I have to read this name out. Oh man. Tufel Hun Deneman. How are you doing? Can I just call you Toof? to I just popped in. You have to come in more often because your name is so good. Thank you. Thank you for coming in. I really, really appreciate it. All you other fibers out there lurking, I appreciate you watching. I really do. Watching is the best thing you can do. Watching my videos is the very best thing you can do for me and this channel. So thank you so much for watching. If you never come in here and chat, that's fine. It's fine. Just know that wow. You guys are I want someone to do it without the at in front of it. Fozzie. I know, Tina. I'm sorry. I'm sorry. It was exciting. It was like exciting to see the you have to take 10 steps. You have to touch oh, he didn't do touch your nose, but we don't get to see that on this channel because I don't do very many body cam videos. And this was start to finish. We got to see the crash, we got to see the body cam, we got to see the verdict. No, oh man, oh Shannon, I wish I could hear you say that in your lilt, in your Irish lilt. Oh, oh, look at you go, guys. You I wouldn't even try. Donald's still using his never mind. So, hey, Linus. Thank you so much for coming out, everybody. I really appreciate it. Remember, this stream that I'm putting on later, please do not feel you have to attend. It's fine if nobody attends. It's going to be long. But let me tell you what I have. I have Chrysanthou. I have the greatest lawyer ever. And I'm not sure she wins all the fights, guys. I'm just saying, this other lawyer that's with her is just as good. He is just as good. So it's like Chrysanthou versus Chrysanthou, and then a judge like poking around, putting his 2 cents in every once in a while, but no, nobody's really listening to the judge. So, oh, and the stream that I'm doing later is offensive in almost every single way possible. So if you're easily offended, please go watch a cooking video instead. All right? Thank you so much for coming out. I really, really, really just appreciate it. I have so much fun every day. I hope you do too. I will talk to you later today. See you in Judge Fleischer's courtroom, guys. Bye.
Got these lights that cause digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes mirror sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted saw. In a way, there's no law.